Good afternoon, everyone. We welcome you this afternoon to an offering from the Innovation Cell of IGNO Real Center Vadagara. As you are aware, IGNO Real Center Vadagara has been operating its innovation cell for the past 2 years, and a number of activities have been conducted, and a number of activities will be conducted in future also under the auspices of this cell. In fact, we are fully aware that innovation is a way of life as far as the current scenario is concerned. Ever since COVID came in, there are a lot of technologies which have been applied in everyday life, on and off. And all these have been the product of innovations at one level or the other. And today we are indeed happy that we have the presence of eminent experts among us. First and foremost, let me bring to your kind attention the presence of Dr. O.P. Sharma, the head of NCID IGNO. Sir, it is my proud privilege and pleasure to welcome you to this forum. We have the subject expert for the day, Dr. Kavita Chalakal, Assistant Professor, Inter-University Center for IPR Studies at the Cochin University of Science and Technology, which is based in Cochin. Madam, it is a privilege to welcome you to this session. Madam will be delivering a talk on an introduction to patent law and procedures in India. It is also my proud privilege to welcome my colleagues, Dr. Pramila O, Assistant Regional Director at IGNO Regional Center Vadagara, and Dr. Praveen, our Assistant Registrar at IGNO Regional Center Vadagara. Welcome to both of you. And it is also a privilege and a proud moment for me to welcome all the participants who are viewing it live, this program live on YouTube. I'm sure this session will be of immense benefit to all of you, as many of you who are participating in this program are indeed innovators at various levels. And therefore, this topic, that is introduction to patent law and procedures in India, is of great importance to each and every one of you. And we are all aware of the fact that intellectual property rights has come to occupy a major role in the commercial life of every citizen of this country. When we talk about intellectual property rights, the main things that, the main aspects that come to our mind are basically the copyright, the trademark, the industrial designs, the geographical indicators, and including the patent aspects. But there are many more aspects of a vivid nature associated with this omnibus term intellectual property rights, on which we shall dwell a great deal on this day. Without wasting any further time, let me welcome O.P. Sharma sir, the head of NCID Delhi IGNO, to deliver his presidential address for the day.
Thank you very much, Dr. Ajay, and good afternoon to all of you. I'm really very happy that we are having an expert in the field of IPR and patent, Dr. Kavita. Just for your information, Dr. Kavita, I would like to tell you that the National Center for Innovation and Distance Education at the headquarters of IGNO, along with the regional centers, we are trying to basically inculcate a culture of innovation, entrepreneurship, and startup among our students. And we have a very large number of students spread all over the country. And over the past few years, we have noticed that many of them are highly interested in doing something at their own as far as the innovation is concerned, entrepreneurship is concerned, or they are willing to start up also. So in that context, we have seen that these all students basically they are coming up with very innovative ideas. New ideas are coming for solving the problems of the society, and many of them have set up their startups also. And for that purpose, we at the National Center for Innovation Distance Education at headquarters, we have been organizing various kind of activities for them, uh, basically aimed at identifying such students, because we know the students are spread all over the country, and it is very difficult to reach out to all the students. So we had, in that context, devised some innovative ways of identifying them. Innovative ways I can just name a few of them, like a Student Innovation Award. The Student Innovation Award is a scheme, annual scheme of the university, in which we invite the students to submit their innovations, innovative ideas every year. And out of those, few of them, like a three or sometimes more than three also, are being awarded with the Best Innovation Award. And this is continuing every year. So that way we get to know that there are many potential innovator of IGNO. Similarly, there are schemes of business plan competition, idea competition, and also an online platform we have created, that is IGNO Udemy, which is basically open 24 by 7 for all the students. So any student who is interested is having some innovative idea, they register there so that they come in our contact, and thereafter we take them into our contact, like for training purpose, for providing them different kind of that, support, guidance, mentorship. So these all things we have been doing. But while discussing, while interacting with the students, we have noticed that they are not well aware of the copyright of their ideas, how to protect their ideas, how to get patenting, what are the different ways and means, at what stage basically they should come forward to protect their idea. Even many times we have seen they are sharing their ideas openly. They don't know at what stage it should be revealed to the people, to their colleagues, to their friends, or to the teachers. So these kind of problems are there. So I think in that context, today's initiative is very important, very relevant for all our students, because we know very large number of students of IGNO, they are coming forward with very innovative ideas, innovations they are doing. They are coming with very innovative business ideas, business models. But I think today's talk will certainly help them being, we can say, aware of the things at what stage, what kind of initiative, what kind of steps they should take to protect their ideas. Without taking much time, I think Dr. Rajesh ji, it will be good to listen to Dr. Kavita, our expert of today's session. And I welcome you again, and we are really thankful to you, because this initiative of Regional Center Vatakara is very innovative in the sense, again, that they are inviting students and they are reaching out to the large number of students through technology, and making them aware of their rights and the knowledge related to the IPR and patents. So thank you very much for giving me this opportunity to share with you my views. And let us now listen to her without wasting much time. It is a pleasure to listen to Dr. Kavita. So thank you very much.
Thank you, sir. Thank you for those very kind words. And you have been always a source of encouragement for all innovative activities throughout the country. And IGNOR Rail Center Vadagara is no different. We have always taken inspiration out of all your measures which have been taken from time to time. The way IGNOR has progressed in the field of innovation says much about the style of functioning that you have developed at the headquarters. And in the area rankings also, we are ranked number one in the particular category of government run central institutions. That owes much to the innovative effort and kind of methodologies which have been developed at the headquarters by you and your team, sir. So it is indeed an honor to have you in this program, sir. And as you just mentioned, we shall now move
Dr.
on to
Rajesh ji,
Madam Kavita
this is the
for
joint
presentation.
effort.
Yes, sir. Yes, sir.
Yes, this is collective
And
effort. We are
before moving
simply
on to Dr. Kavita,
leading, otherwise we are getting support from all of you, all the regional centers, all the colleagues at the headquarters. Because of that, we could get this ARIA ranking first
yes, thank
in
you,
these central universities, and we also in IIC we have got very good rating every time. So that is
exactly,
that I can say uh, the credit goes to all my colleagues at the regional centers. So now we are really thankful to our vice chancellor and co-vice chancellor that they are encouraging our regional centers also. Recently, I had seen a mail from our regional director, regional service division, and all the regional centers, they are now setting up their innovation clubs at all the regional centers. Earlier it was at 25. Now I'm getting mail every day that it is increasing day by day. So innovation clubs, innovation cells are being set up at all the regional centers. That way, we are creating a great moment that among the students. So this kind of mission mode working will certainly help us in creating that culture of innovation in the university. Thank you very much.
True, sir. True, sir. Very true, and very correctly said. IGNOU is moving fast in the process of innovating most of its activities and processes, and the kind of ecosystem which is getting developed in the university is a matter of great pride for all of us. Before going on to Dr. Kavita for her presentation, I would request my colleague Dr. Pramila O, Assistant Regional Director, to briefly introduce our guest of honor, Dr. Kavita, and so that our wider audience gets a view of the kind of accomplishments that Dr. Kavita has made in her professional and academic field. Over to you, ma'am, Pramila.
Thanks, sir. Respected Dr. O.P. Sharma, sir, the head of NCIDE IGNOU, Dr. M. Rajesh, the regional director of IGNOU Regional Center, Vadagara, and Dr. Kavita Chalakal, assistant professor, Indian University Center for IPR Studies Research, and Dr. Praveen Kumara, the assistant registrar of IGNOU Regional Center, Vadagara, and all other participants. A very good afternoon to everybody. Today we are conducting an online seminar on the topic Introduction to Patent Law and Procedures in India as a part of the Innovation Cell activity of IGNOU Regional Center Vadagara. We got the presence of an eminent personality for this event, a subject expert, that is Dr. Kavita Chalakal, the assistant professor of research, and it is my duty to introduce Kavita Chalakal. About Madam. Madam completed her PhD in International Environmental Law from Jawaharlal Nehru University in 2014. MPhil in Public International Law also from JNU in 2008. Master of Law from Cochin University of Science and Technology in 2006 and LLB from Kerala Law Academy Law College, Thiruvananthapuram, Kerala University. And Madam also selected as the first Foundation Fellow for the year 2009-10 from the university in USA. Also received the Research Fellowship from China South Asia Legal Research Center in the year 2018. Madam also having the following memberships: Member, World Commission on Environmental Law, International Union of Conservation of Nature, Member, World Commission on Protected Areas, International Union for Conservation of Nature, Associate Member, Indian Society of International Law, New Delhi. She has also been also working as visiting faculty of Indian Society of International Law, New Delhi from November 2017. Before joining as assistant professor at research, she worked as assistant professor at Christu Jayanti College, Bangalore North University, and also assistant professor at Amity Law School, Delhi. Also worked as assistant manager, Wildlife Trust of India, New Delhi. Madam's contribution in the area of curriculum development is also remarkable. She has developed 4 MOOC e-content for postgraduate courses for the e-Padashala project MHRD, Government of India. The other notable achievements of Dr. Kavita are as the selection of Best Presenter for second International Conference on the Contemporary Legal Issues, School of Law, Greater Noida, and Best Presenter and Best Paper for CLEA Conference on Comparative Constitutional Law, Modi University, Rajasthan. And she has a number of paper presentation in her credit. And this is the brief about her data. And also, I take this opportunity to welcome Madam. We are waiting for your words. Thank you. Back to Rajesh sir.
Thank you, ma'am. Thank you for introducing our guest of honor, who will be delivering the keynote address for this section. It is indeed a privilege and a pleasure to have her presence here. And as our audience would have just realized, she has an enviable repertoire of accomplishments on her name. And without much ado, let me welcome Dr. Kavita once again and request her to make the keynote address for the day. Over to you, ma'am.
Thank you, sir. Please let me know whether I am audible.
You are perfectly audible, ma'am.
Yes. First, good afternoon, everyone. I would like to extend my sincere thanks to Dr. O.P. Sharma and Dr. M. Rajesh for giving me this opportunity for taking a class on Introduction to Patent Law. I also thank Dr. Pramila O for such a beautiful, I don't know whether I deserve it, introduction. Thank you so much, ma'am. So, shall we start on the presentation, sir? May I start with the session?
Sure, ma'am. Please go ahead, ma'am.
Yes. Yes. So, good afternoon, participants. Today, we will be having an introduction to patent law and procedure in India. As Dr. O.P. Sharma sir and Dr. Rajesh sir had said already, intellectual property is something which all of us are aware of, but at the same time not very keen to protect, or we are sometimes unaware of how we should protect our intellectual property. So, due to its nature, somehow we associate intellectual property as something which we cannot see or which we cannot quantify. We have the tendency to distinguish or keep it separate from traditional notions of property. So today in this presentation, what I'm planning to do is that I'll give a very brief introduction to the concept of intellectual property, and then we will briefly touch up different types of intellectual property very briefly, and then we will move on to our core area, that is patent law and procedure for obtaining a patent in India. So let us start with the importance of what is IPR and why we need that sort of awareness of IPR. Intellectual property rights or the intellectual property has become one of the major economic and market concern, and internationally it is said to have more than $6 trillion in value as of 2022, which is always on the rise. So there are a couple of differences between an intellectual property and a traditional tangible property, which we will discuss coming in the coming slides. So first thing we need to understand is that sometimes many of us consider IP means intellectual property, IP as a monopoly. So we need to understand that intellectual property in its legal and technical sense is not a monopoly as such. A monopoly is where there is only one player with unlimited power and unlimited time. But when it comes to IP, we need to understand that intellectual property is a right which is given by a law. So we call it a statutory right. If there is no statute, if there is no law telling you that, okay, you can have this patent or you can have this copyright, you don't have an IP. So it is only recognized by law, and it also has certain limitations. It is not like a monopoly where you have an unlimited way of doing things with regard to the property which you own. So before we go to what is property, let us intellectual property, let us understand what is property. Property, when we think about property, the first thing that comes to our normal mind is a plot or an apartment or a house or a piece of thing which has value, or maybe gold or a car. But when you think about property in the legal sense, as I'm a law teacher, I have the tendency to move more into law. But in legal sense, property means a set of rules that govern people's access and control of things. We just need to understand that if that thing has a value, you have a set of law which is controlling your ownership and which allows you to access that. So it could be land, it could be natural resources, even negotiable instruments like checks, DDs, then goods, and then we have this new category which came up, that is the intellectual property, that is a creation of your mind. Now the question is, why do you need property? How can you take the property? So there are different theories which is basically anthropological and legal. So some of them are sociological also, sociology. So when you think about property, you need to understand that it is a construct, it is a structure which is created by the society with the help of law. So you can be like, first time I occupied it first, so it belongs to me. The first occupation theory comes there. Or you can say the fruit of labor, I vested my money, my effort on that. So the fruit of my labor should belong to me. Or it could be of a utilitarian aspect, saying that property gives maximum happiness to people, so you should give property, which is a state's action. Or it could be a concept called personhood, where you feel that your personality is more relevant when you have property with you. So when we think about property, we have different kinds of property. So instead of going with conventional tangible property, etc., I'm just going with movable and immovable property, such as car, pen, furniture, or immovable property like land, building. And at the same time, you also have an intellectual property. Those are the creations of your mind, which is basically your intellect. So when we think about property as a right, we need to understand that property gives you a set of rights. So this set of rights will include essentially right to transfer, right to exclude others from using your property. It's very easy to understand. If you have a house, you decide who can come and stay in your house. You decide who can sit in your sitting room. So you have the right to exclude others from entering your property. You have the right to use, you can rent, and ultimately, if you feel like destroying your property, you can destroy your property. No one is going to prevent you from destruction of your own property, although all these rights are subject to the law of the land. So in India, we have a set of laws starting from the Constitution of India. So all rights which we are vested by these statutes are essentially controlled by this law of the land. Other than that restriction, you have these type of rights when it comes to the property. Now we are moving on to the concept of intellectual property. So intellectual property is something which is created using human intellect. So that particular word, human intellect itself, creates the limitation for new type of inventions to come in. Those who are participating in this session would know that artificial intelligence is coming up in such a way that it is amazingly replacing human beings in many of our activities. So the question is, when is AI capable of being being an owner of a property? So as of now, AI is not allowed to give a property status, not to give the ownership status, because law only recognizes certain categories of entities. It could be human beings, it could be incorporations, it could be deities. So only certain type of entities are allowed to hold property as per law. When it comes to intellectual property, it is basically something which is produced by human intellect. And again, compared to the traditional tangible property, that is movable or immovable property, IPR is considered to be somewhat of an abstract nature. The limitation, how to set the limitation, how to identify where it is forms the abstract of it. Now, that doesn't mean that IP is going to protect something which cannot be limited, which cannot be kept in a box. Box in the sense not in a solid form, but something where we can draw the limitations. So the limitation comes in such a way that even if it is the creation of your intellect, only the physical embodiment or the expressed form is protected. So for example, suppose I have a very good idea for a novel in my head, and I'm thinking about this, like most of those if we are in academics, we all have that problem. We have great plans to write papers on, but somehow most of them don't realize or materialize. Suppose I was thinking of writing a novel and it was a very good one, but I did not write it down, I just kept it in my mind. But someone say, my friend wrote that particular novel. I cannot go and say that my friend copied from my novel, because my novel was never expressed. Same goes for patent also, which we will discuss. in a short while. So only the physical embodiment or the expressed form is protected. So unless your product, your intellectual product is capable of being expressed, capable of being physically made, you might not be getting a protection. And like a tangible property, an IPR also once registered under a statute. It could be patent law, it could be copyright law, trademark law, geographical indications law. Unless you are registered in one of these law, your rights are like it's exactly like the tangible property. You can assign or bequeath, like you can your heirs, legal heirs can inherit your property. Anyone who trespasses into your account can be held accountable for that, and you have the exclusive right to exploit your property. Now, I have been saying the intellectual property from for a long time, but what is intellectual property? So, there is an organization, an international organization called World Intellectual Property Organization. So, this organization is entrusted with the task of helping the nations to come up with their intellectual property laws, or helping the countries globally to create standards for protection of various intellectual property laws. So essentially, we need to understand that intellectual property includes the rights relating to a set of things. So it could be a literary, artistic, or a scientific work. It could be performances. It could be inventions. It could be scientific discoveries, industrial designs, trademarks, service marks, commercial names and designations, and protection against unfair competition. So WIPO convention on IPR, it gives the definition of IPR as this. So anything, any among them which you consider is the product of your intellect can be given an IPR protection. So when we look into IPR, we need to understand that IPR, since in the first or second slide we discussed why you call it a monopoly. So the monopoly nature of IPR comes from the fact that it is given to an individual for a particular time of period. So we need to understand how this particular concept is regulated, how the law regulates it. So IPR is a domestic statutory right. That means IPR is only protected if your country has a law on that. And this law, for example, the Indian Parliament makes the IP laws applicable for India. And the Indian law is going to be in compliance. It would be the standards or the mode of protection would be as per the international law, which has been created by many states. They come together, maybe under the WIPO leadership or under the WTO, World Trade Organization leadership. They have TRIPS, the Trade Related Intellectual Property Rights Agreement. So under this leadership of this international organization, they come up with standards. So when you are having a national law, it is your duty as a state to oblige with or to comply with the obligations you have undertaken globally. And the subject matter, like as I said, there are different types of IP, and the nature of rights also vary according to the type of IP you are getting. Each type of IP is different, and it differs from subject matter. That means what is protected, term of protection, how long it is protected, and the fee for registration also. So now, even though a single thing can be covered by multiple types of IP, it could go under patent as an idea and as an invention, or it could go under copyright as a sketch or exhibition or a 3D projection of something, or it could go to any other type of industrial designs or somewhere. Whenever you have multiple choices of IP for your product, it is always advisable that you look into the type of business you are engaged in and what is the best mode of IP which would help you. So all these types of rights will help you in identifying which type of IP is most suitable for your invention. There are, of course, subject matter classifications in patent, copyright, or trademark. We have subject matter classifications, but at times, some inventions can be maybe covered by multiple type of IPs. So basically, when we think about IP, as I said, we have the tendency to call it as a monopoly. But we need to understand that it is not always a monopoly. especially from a developing country perspective, we need to understand that intellectual property is something which is trying to balance the private interest, that is the investor's interest. Someone who is investing the money, his investment should be protected, and at the same time, the monopoly period, which we call as an exclusivity of 20 years or lifetime plus 60 years or 10 years as per the category, that type is what is the that particular time prevents others from using that particular IP. So the public interest is also balanced between these IPR. So on one hand, you have the protection for your investment. On the other hand, you when you get an IP, you are vested with the duty to make it available to the public, make the technology disclosed to the public, etc. So we need to understand that IPR is not just a monopoly, which we very commonly understand. It creates a set of exclusivity. That is, only a single entity can use that or manufacture that or sell or offer for sale that particular property. Now, there are many justifications. The question is, when we call it an monopoly, when we call it an exclusivity, why do you give IP then? Let us take away IP. But then, if there is no incentive, people might not invest. If there is no reward for my effort, I might not work. And then there are many property theories also which allows or identifies that property is essential for an individual's growth. So these are different IP justifications, and we say that without a proper intellectual property regime, it might directly affect the creation, innovation, commercialization, protection, and enforcement of the rights which are vested with this type of property. So this if you are clear that you are going to get a patent, that no one is going to take away your invention for 20 years, you may invest better, you may work better for your invention. Now, as I said, there are different categories of IP, but we can see that IP is, let me just take my point. Yes, IP is basically classified into two major categories. One is industrial property and the other one is artistic property. Artistic property essentially includes copyright and related rights. That means rights for your literary, artistic works, etc., drama, cinematography, musical works. All of them are falling under the concept of copyright. And then you have the broadcasting rights or performers' rights, which are called as the related rights. And in industrial property, as our classes on patent, I have just emboldened it, but it has other types of properties such as trademark. We have the marks which are like, we are very familiar with trademark. We, for example, what we say, Adidas or Pepsi, Coca-Cola, then Tata, all of them are very famous trademarks. Godrej. Sometimes we have even started using the trademark as a product name. For example, sometimes instead of saying photocopying, we say Xerox. Xerox is actually the name of the machine which photocopies. And many at a times, instead of saying top ramen or YY, we just say Maggi noodles. Even if it is normal noodles, we call it Maggi. So we'll just go and have a plate of Maggi, or we will just go and buy a Johnson powder. It might be Wipro, it might be Biotic, but we have the tendency to call it Johnson. And at one point of time, where before the mobile phones, the smartphones encroached into our life, we had this traditional cameras, and those who have used those film cameras would remember. Even most of the time, the cameras were known as Kodak cameras, because Kodak was a very popular company which gave very good quality cameras. Or Walkman. Only Sony came up with the name, Sony company came up with the name of Walkman. But once we started getting Walkmans, or portable radio tape record player, we call all portable ones as Walkman. So trademark includes that. Then we have the industrial designs. Industrial designs is basically the external appearance of how a particular thing looks. Might be what do we say, a bottle shape or a vessel shape or a mobile phone's design, a car design, basically how it looks is what is industrial design. Then we have geographical indications. Geographical indications are those indications or what we say, pointers to the geographical location from which that particular product comes up. So, for example, Kanchipuram sari is there, basmati rice is there, Darjeeling tea. Then we have, like in Kerala, we have a lot of rice varieties. And recently, I think some of the plantain varieties like Changali Kodan or Palakkad and Matta or Aramula Kannadi, all of them are geographical indications. So this indicate, there was recently, like 2 years back, there was even a what is a sort of a struggle between Odisha and West Bengal regarding Rasgulla also, whether it should be the Bengali Rosgulla or the Odisha Rasgulla. So there are, like, those are the fights which are with the GI related things. Then we have the plant variety protection and farmers' rights, that is the PVP and FR, this particular category. This is a very indigenous, sui generis type of protection India is offering for new types of plant varieties or the farmers' varieties which were already existing varieties, etc. So some of the countries give the protection for plant varieties in patent, but in India we are having a different law for that. So any new type of a plant which was already notified by the authority, you can get a plant variety protection for that. Then we have the trade secrets, some of the well-known secrets in the world, or some of the well-known works in the world is still under the trade secret. For example, most of us use the Google search engine, right? Like when we have to something, instead, even if we are going to search in what we say Internet Explorer Edge, or if we are going in Firefox Mozilla, we still say it Google. We don't say Internet search. We'll just say, why don't you Google it instead of using Internet search? That is a trademark which has become very general. Now coming back to the trade secret, that algorithm of the Google search engine is a trade secret. It is not getting a patent or it is not getting a copyright for that particular software, because if you keep it as a trade secret, at no point of time will it be divulged to the public. Similarly, like the common, what we say, the combination of the KFC chicken, or the combination, the alloy combination of different varieties of things which we see, most of them are trade secrets. Some of them even say the Coca-Cola syrup is a trade secret. So trade secrets could be of any category. It could be from food industry, it could be from agriculture industry, it could be software, it could be machine, but those trade secrets is another type of intellectual property. Then we have the semiconductor chips and layouts. So those who are very curious in your childhood, whenever you open electronic device, you would see a green panel with the transistors and conductors, like, with the sort of, it looks like a matrix premise. So that is known as the semiconductor chips and layout. So they are also getting a protection. So these are basically the different types of IPR which we need to be aware of. Then we are moving on to our core area, that is patents. And before we start, with the patent, I want to tell you basically that this is a huge area, and we are only going to touch a part of it today, because in our center we teach it as 2-3 papers actually. So we will be just getting an introduction to patent. So let us say, why do we need patent? So when we think about patent, this is a very funny depiction which I really like a lot. A person invented a wheel, and different people had different idea to use that wheel. So each of them, each of their creativity, each of their curiosity was, what we say, enticed because this person invented a wheel. Now, what is a patent? So with this background, let us go to the concept of patent. Patent, as I said, is a statutory right. That means if you don't have a law giving you a patent in India, you cannot have a patent. And this is an exclusive right, exclusive to the person to whom it is granted, for an invention, and it could be a product or a process that provides in general a new way of doing something, or offers a new technical solution to a problem. So, what we need to understand is that first, if it is not given through law, you don't have that right. Second, it is an exclusive right. And third, it is only given for an invention. So, the property on which you are going to get a patent is an invention. We need to be very clear that an idea is not patented, a mark, a trademark is not patented, a poem is not patented, an article is not patented. It's only an invention which is patented. And this invention can be a product or a process. And that provides in general a new way of doing something. You have a new innovative way of doing something, or you have come up with a new solution to an existing problem. So this is what a patent is. And we need to understand that it is not an affirmative right, it is a negative right. So we call it a negative right because basically you can stop others from doing things. When we come to the rights of a patent, you will understand it better. But we need to, as a introduction, you need to remember that you don't have the right, not you don't have, the law doesn't tell you you can do that or you can do this. What the law says is no one can do certain things without the authority of the right owner. So it could be for making, using, importing, etc. And when you get a patent, as I said earlier, it is a balancing of private interest and a public interest. What happens is that now it is more systematic, it is more regulated by the law. But previously, patent sort of created a monopoly. And at one point, what they will do is that they will make a slight improvement to the existing invention, and because of that improvement they will try to extend the patent term. That is known as evergreening of patent. It is still a major issue in many sectors, but to stop that, to ensure that if you are getting 20-year monopoly, you are going to give something to the public. So when I am applying for a patent, I have to give an explanation of what I am going to patent. And this explanation is known as the specification, which is basically a disclosure of my invention. And once the term of my patent is over, that is 20 years from the date of application. Please remember, it's not from the date of grant of patent, it is the date of application, and at times it takes 4 to 5 years for your patent to be granted. So the 20 years from the date of your application is the term of your patent. At the end of the 20 year, this disclosure, the technical information which I have provided to the patent office, will be made open to the public. That will allow the public to come up with more inventions or innovations. So when we look into patent, it has a very long history. It started somewhere in the 13th century. Some say in the 14th century also. But it began not with invention. It was basically to the weavers. So the weavers in London, they found a particular way of weaving woolen clothes. And that was the first patent which was given. Then you had the, a new method of in 15th century, one of the, the data which is available in 15th century, making of salt or manufacturing salt in a big way was identified as a method capable of getting a patent. Then in 1474, Venice was the first country to come up with a patent statute, and this has Venice has one of the earliest patent system in the world. If you are interested in the world history, you would know that Europe, especially Venice, Paris, etc., they were the core of Renaissance movement, and most of the industrial revolution, innovation, etc., began from that particular area. Now, with that, even though the patent originated there, later on, with the British becoming one of the biggest colonial powers in the world, the moment the British had a patent law, all its colonies started getting a patent law, and India also followed suit. Our first major patent law was in 1911. Then we have in 1970 the post-independent one. Right now, our patent law is the Patent Act 1970 as amended in 2005. So, what are the objectives of patent law? Because whenever we hear IPR, we have this tendency to understand it as something which is basically restricting the public access to a particular knowledge. So technically, or what we say, the policy framers identify patent as a method or a tool to encourage scientific research, new innovations, technology coming up, and industrial progress. So it's identified as a circle where the assurance given to the investor prompts or encourages them to invest more and more. And when there is more investment, essentially new technology should come up. And once this technology come up, you have further technology developing on it. One of the we can all understand how the technology has jumped. Previously, it was crawling in the 14th and 15th century. It jumped because with industrialization, there was a huge, what we say, leap in the way the technological developments happened. So we need to understand that. I'm sure most of us still remember the days where we used to have only a landline phone, and from there we had landline wired phone. From there we had a codeless phone. From the codeless phone we had feature phones. In between we had a thing called pager. Very few friends of mine have used it. And the pages were very quickly replaced by the mobile phones, that is, the feature phones. Then the feature phones were replaced by the smartphones, and the smartphones were what we say were the technology which is coming up in smartphone is like something unimaginable. So the scientific technological progress is one of the main objective of patent law. So when you are giving an exclusive privilege to an individual or to an entity or a company, you are actually stimulating the new inventions which is going to be commercially useful for the population. So the policymaker says that, oh yes, we are giving you 20 years, but that price for the grant of that 20 years is the disclosure of the invention at the patent office, which after the term of the patent passes to the public domain. Excuse me. So let us see patent is not something. When we think about patent, we should not assume that patent is only given to something which is very complicated. So at one point when the water gun or the lemon squeezer or the bathroom tissue holder and even a traffic signal, all of them were given patent. So it is basically whether you are fulfilling the requirement, whether you are fulfilling the standards which are required in a statute, which allows you to have a patent. So the novelty, I'm sure, of course, none of them are novel now, but at the point of invention of these things, they were very normal. I mean, they were very new, and it was like it was innovative. And I think this lemon squeezer, I really like it. The benefit is that the lemon juice doesn't go out. So these were like again another example is one of the what we say the first noodles, which all of us are very familiar with. For the first time, they got a patent for that. The chicken ramen and that instant noodles, kappo noodles, which we call, Nissan now has it. So this, what we say, this particular noodles was given the patent, and it was only because of, they say that it was only because of patent that they got the what we say the type of noodles which we have now. I just kept this page or this particular image. This is an image from 1907 where the toothbrush, a normal toothbrush, was getting a patent, and on the other hand, you also have an electrical toothbrush which is getting a patent. So if a person who is seeing this figure, along with the explanation, if we get this figure, we can understand that the person can make a invention which is similar to this. Nowadays, we can't even assume getting a patent on a brush, but at one point, when it was new, it was given a patent. And these are different types of brushes which came out as a as a result of that. Like it has a spring, so it has far reaching, it may bend according to your what we say, your jaw shape. And this one has gone one step ahead, where you can just it's exactly in the shape of our teeth, and it gets brushed. So like then we move on. This is how the technology has progressed when it comes to brush. And in 1937 we have this electric brush which has a round edge, and it, it just rotates and rotates and your teeth is cleaned. And from there, now we have, this is the latest model of your what we say, the brush we have, where you can keep your what we say, toothpaste can be kept here, which will automatically be given into that. So this is how, see, from here, from this one 1907, the world of toothbrush has moved a lot, and it has now reached here. So that is how people say that, or that is how many uh, what we say, supporters of IP say that this is because of IP that there is a lot of innovation. Now let us come to the Indian context. In India, right now we have the Patent Act 1970, which was amended they later in 2005, and it is TRIPS compliant. TRIPS compliant means when World Trade Organization was established after the GATT 1947 came to an end, and the Marrakesh Agreement established the World Trade Organization, it had multiple agreements under that. And one of the agreements under WTO was known as the Agreement for Trade Related Intellectual Property Rights. And this, the inclusion of intellectual property to the international trade law, created a lot of criticisms, lot of issues. And the major problem for India was not just TRIPS being a part of WTO. We had created a space globally for our pharmaceutical products. All of you would be very much aware of how the Indian generic pharmaceutical industry is thriving, and how big that particular industry is. It has gone to that extent where we call India as the pharmacy of the global south, India as the manufacturer of the global pharmacy, etc. So we had achieved that particular status by excluding certain things from patentability. Now with TRIPS, the developed countries and the other, particularly US and European countries, they were very concerned about the Indian generic market. And they were concerned because this generic industry was growing so much because of a loophole in patent law, and they wanted to plug that particular hole. They wanted India to have a standardized patent law, and it mandated that if you are signing WTO, you are being signatory to the TRIPS, and if you sign TRIPS within 10 years, they gave different transition period. For developed countries, it gave 1 year. Developing countries, it gave 10 years, and least developed countries, it gave 20 years. So we were given 10 years, that was which came to an end on 1st January 2005. That is why it is known as amended in 2005. And we had to amend our existing law to be TRIPS compliant. Now, this is the new sections. These are like after 2005 amendment, and I'll be telling you how it is different from the previous one. So, according to the, you may remember the section, but what I want you to remember is patent means a patent for an invention, any invention granted under this act. So, our first question is to understand what is an invention, because if it is an invention, it can get a patent. So, the law says that invention means a new product or process involving an inventive step and capable of industrial application. Now, this is how, or this is what is important when we try to understand the concept of patent. What is an invention? What is to be patented? I have seen two questions. I'll be addressing it towards the end of the class. Okay. Now, an invention, as what can get an invention, is either a process or a product. Previously, to create a food security and health security, because independent India was very poor, we were just surviving from the British imperialism. to World War, Bengal famine, drought, etc. So the Indian government decided to keep two categories out of patenting. One was pharmaceutical products and the other one was agricultural products. The purpose was to ensure the population has health security and food security. However, with the TRIPS agreement, when we signed the TRIPS agreement, we need to understand that TRIPS said you cannot exclude anything. Any type of technology, whether product or process, should be given a patent, provided that it has a newness to it, it has an inventive step to it, and it has an industrial utility. So with these three things, you can get a patent. So that essentially means our product patent exclusion for both what we say for both agricultural patent, so agricultural products and pharmaceutical products are now taken away. So that means the generic drug industry is now being affected. So one of the best examples to understand the difference between a product patent and a process patent is to remember, I usually say 3 plus 3 is equal to 6. So if we take 3 plus 3 as a process, the product is 6. So when both the product and the process is protected, you cannot use 3 plus 3 and you cannot get 6 by any other method. Now the problem is, if the product is excluded, let us say 3 plus 3 is the only part which is protected. That means you can go with 2 plus 4, 5 plus 1, 7 minus 1 or 8 minus 2. You can go any way to reach 6. Now the problem is even the 6 is protected now. That means you cannot use an alternate method to get a new product or the similar product. This essentially stopped the what we say the availability of the product which we reverse engineer. When we get a drug, the process is protected. Okay, let us keep it out. So you take the drug and you start reverse engineering it. You see what are the compounds used, and then you get a patent for that. That came to an end with the 2005 amendment or the TRIPS standard which we need to follow. So along with this condition that it should have a newness to it, it should have an inventive step, and it should have an industrial application, there are certain other exclusions also which is related to patent. So let me just, yes, it says that there are certain things under the Indian Patent Act which says that you cannot patent them. They are an invention which is frivolous, which is not of any value, which is contrary to well-established law, or which is against the public order or morality, or which causes serious prejudice to human, animal, or plant life, or health, or to the environment. You cannot what we say patent a discovery, because discovery is something previously existing. You cannot patent an abstract theory. You cannot patent a living thing or a non-living substance which is occurring in nature. You cannot patent a new form of a known substance which is not resulting in any enhanced efficacy, or you cannot patent a new property or a new use. So basically, those who are from the science background would understand that salt esters, ethers, polymorphs, metabolites, or the alpha form to beta form, all these isomer, all these are known as the of a same substance, will be considered as the same substance. So the salt form of one thing, or the alpha crystalline form or the beta crystalline form of the same compound will be considered as the same substance. So if you have a new form of a known substance, it is not patentable. A mere admixture, like you are mixing certain things and you find that you are saying that, okay, this mixture created a new product, that cannot be patented. Mere arrangement or rearrangement or duplication of known devices cannot be patented. A method of agriculture or horticulture, diagnostic, therapeutic, or treatment of human beings. So, for example, we have different physiotherapy, psychotherapy, then music therapy. All these are different forms of therapeutic methods. So those type of therapeutic methods cannot be patented. Diagnostic method, how you diagnose a disease. If it is what we say a normal method which we use, it cannot be patented, or a treatment method cannot be patented either for human beings or for animals. So I'm just I just kept a couple of examples: narrative therapy, aromatherapy. All these are out of the concept of patentability. Then diagnosis like actual nursing diagnosis, or identifying the health actualization of the human health potentials. So basically the diagnosis which the doctors and nurses use in their day-to-day routine life is not patentable. Plants and animals in whole or any part thereof cannot be patented. Essentially biological process for production or propagation of plants and animals cannot be patented. Mathematical and business method cannot be patented. Computer program per se or algorithm cannot be patented. In India, computer program is protected under the copyright law. At the same time, a computer software, which is a combination of multiple programs, can be protected under patent law as a computer related invention. So you need to understand that the computer program is different from a computer software, which is similar to a computer related invention. And further, it excludes like literary, dramatic, musical, or artistic work. That is a thing which can be protected under copyright, or a method of performing a mental act, etc., is excluded. Then presentation of information is excluded. Topography is excluded. Topography of integrated circuit is excluded. Traditional knowledge is excluded. Most of the time, I'm sure you might have heard about instances such as the neem patent, or the turmeric patent, or the basmati patent, etc. So this is basically the traditional knowledge which is being appropriated as private property, and which is prevented by the Patent Act. Also, any invention which is falling under the Atomic Energy Act, that is invention relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, etc., or any other type of compound as notified by the government, cannot be patented. So those inventions which may use these type of compounds are also not patentable. So we'll just have a quick recollection of what we discussed for the last 30-35 minutes. For example, so we can say that a patent is given if it has. Let me just go back to that slide. Yes. So a patent is only given for an invention, and this invention is for a process or for a product. However, the product or process should be new, it should have an inventive step, and it should have an industrial application. That means it should have a commercial utility, and it should not fall under section 3, which we discussed in detail now, the discovery, plant form, animal form, etc. And it should not fall under section 4, which is related to the compounds which we discussed. Now we are moving on. Yes. I have said that earlier, 1 minute, yes, I have said earlier that patent is not an absolute right. I think, Mr. Karthik Krishnan, your patents are not allowed. I think you are clear with that. So it is not actually a restriction on the growth of knowledge. Basically, it is basically trying to keep certain things in the public domain so that there can be more and more inventions related to that. And certain things which are not patentable, such as such as the human form, life form. There are many issues which are many categories which are against the morality and ethics. So we may not like having a designer baby, like that is the new genetically modified things which are coming up, that you design your baby with the IQ you want, with the skin color you want, with the eye color you want. So this designer babies is something against the ethics, it's something against the humanity, or creating something out of the nature. So for example, mating totally two different species and identifying that offspring as a new product, those things are against the natural process, natural order. So these exclusions can be basically because of ethics, morality, and legal restrictions. And on the other hand, it is also to keep the public domain free. So the standards that if it is not new, if it does not have an inventive step, if it does not have a commercial utility, that is kept in the public domain. That means it is something already existing and you are not going to privatize it. So this is not actually a restriction on the growth of knowledge. On the other hand, this can be considered how the knowledge grows, because if the algorithm is not in the public, how can the further softwares develop? If the alphabets are not available in the public, how can others write the novels? How if the formulas, for example, the theory of gravity or the any relativity or any theory, if it is patented or if it is copyrighted, that means no one else can use it. So those things and abstract principles, all these things are kept in the public domain so that there can be further what we say further knowledge growth on that. So in the beginning, I said that patent is not a monopoly, it is an exclusivity, mainly because of these factors. Because it is subject to certain conditions like government use, importation or manufacturing by or on behalf of the government, experimental purpose, research purpose and teaching purpose, and distribution of drug or medicine by government in dispensary. So recently we had that it is still ongoing. We have that heavy impact COVID, which was an eye opener for the global community, the policymakers, the state, and the population. We did not know how to handle that particular pandemic. So there was a huge demand globally to ensure that COVID and COVID related therapeutics or diagnostic medicines and kits are kept out of the patent system. They say that if there are no patents, these things can be made more available. So at times the government may step in. At times the government can ask you to give up your invention, or at times the government even may use it for its emergency purpose. So this patent, the one of the most controversial way of what we say regulating a patent is through compulsory license, which most Western countries are not very happy about a compulsory license. So compulsory license is something through which, if I have a patent and I am not making my patent available to the public, my product available to the public, the government can interfere. So compulsory license is such a tool or a method which are which allows the government to intervene, or which would make the availability and accessibility of a particular products to the general public. So it, this is permitted under TRIPS, so it's not against international law. However, it can be only for domestic use, and it is an exception to combat the adverse effect of patent. So section 84 gives the grounds on which you can get a patent. So, a compulsory license. So there it says that reasonable requirement of the public with respect to the patented invention have not been satisfied. The patented invention is not available to the public at a reasonably affordable price. So the first one is requirement of the public. Second is the affordability of the particular product. And third is the patented invention not worked in the or performed adequately worked in the territory of India. So this is essentially more this is very crucial when it comes to life-saving drugs. So in this context, I just want to discuss a very famous case. This was between Bayer Corporation and the Union of India. So this was with regard to Nexavar, a drug which is for cancer. And one course of that particular drug was costing INR 2,80,000 rupees. And third respondent, that was NATCO, they said that we are capable of making it available for 10,000 rupees per course. That means there is a distinction of 2,70,000 rupees on a single course of medicine. And there were around 17,000 patients who were ready to buy the drug at this rate. It is not that 10,000 rate. So 17,000 patients were ready to buy that drug in this particular, what we say, uh, particular amount of money. So Nexavar, which is basically for the an advanced cancer drug for the renal cancer, kidney and liver cancer, and NATCO actually is, it said that NATCO is the third party to that particular case. They said that they want to sell it for 8,900 rupees, and the question was whether it could be permitted. So NATCO, the law says that you cannot go for the compulsory license directly to the government. First, you have to approach Bayer. So NATCO and other companies actually approached Bayer for a voluntary license, and they said that they are ready to pay the royalty for it. But Bayer Corporation was very averse to it, and it said that it is not going to give voluntary license to the companies, and it will continue the sale of the drug at 2,80,000 rupees. However, so these 3 points which we required, that the reasonable requirement, affordable price, and availability in India was questioned. So among these 17,000, Bayer only gave, I think, for 1,800, 1,800 plus patients only. Rest of them were not. Almost 15,000 patients were not given the drugs. So the government actually intervened, and it said that the Supreme Court actually said that NATCO can make the drug available, and it forced Bayer to give a compulsory license. And 8,900 rupees was what the court allowed NATCO to sell the version for. And it said that while you are selling it for 8,900 rupees, you also need to give it to 600 patients every year for free of charge. Now, this is how a particular intervention, that is why I said monopoly will not be the exact term to use when it comes to the patent. It still has scope for exclusive intervention by the government. Now, what are the rights of a patentee? A patentee has a right to sell, assign license, right to exploit the patent, that includes right to manufacture, right to use, right to distribute the patented item in India. And when it comes to process patent, it also has the right to exercise and direct the method of process. Now, I said in the previously I said that patent is for 20 years from the date of grant of patent, and it prevents you from, you can stop a third party who is doing any of these activities without your authorization. And after 20 years, the technology goes to public domain. Now, I just took a sector which is sort of slightly interesting, and which would be interesting to discuss in the webinar. So we have seen under section 3, we have seen a list of things which cannot be given a patent, such as plants, animals, part of plants, etc. Now that particular thing, ethics, morality, science, discovery, all of them culminate together when it comes to biotechnological inventions. So one of the first instance that a particular biotechnological invention came into question was in the case of a US case. And this case is very famous because in this, the claim was that anything under the sun can be patented. So that particular term, anything under the sun can be patented, can be found. The origin is from this particular case. So this Diamond versus Chakrabarti. Chakrabarti is an Indian scientist who was working in US, and Diamond is actually the US patent officer. So if any of you are from legal background, and if any one of you are studying patent law, you would be finding a lot of cases in 1980s with Diamond as a party. So Diamond is basically the patent officer of United States Patent Office at that time. So the patent application was made by Mr. Chakrabarti for a genetically engineered bacterium capable of breaking down multiple components of crude oil. So you have heard about the crude oil spill. the oil spill which creates a layer of cover on the water body, which affects the oxygen flow of the ocean. The fish is affected, the what we say, the water plants are affected, etc. And cleaning up crude oil takes a lot of effort. So Chakrabarti apparently engineered a bacterium which is capable of, that is Pseudomonas putida, which is capable of breaking down this crude oil. And it it first it applied for a trademark, it was rejected, then it applied for a patent, and the patent was applied in these three categories: process, method of producing the bacteria, slurry of bacteria and carrier liquid, and the bacteria itself, the Pseudomonas putida. So Diamond took the stand, the patent officer took the stand that this bacteria cannot be patented because it is a living thing, it's a living organism. Then the US Supreme Court, on appeal after appeal, it reached the US Supreme Court. It held that a genetically engineered microorganism can be considered as a patentable subject matter because it constitutes a manufacture or composition of matter rather than a pre-existing bacteria, because the pre-existing bacteria were not capable of breaking the components of a crude oil. So in this case, for the first time, you have a microorganism which is being patented. The next case, which is very interesting, is it's a EU case, and like this was with regard to Dolly, the first cloned sheep, the lamb called Dolly. So it was Campbell and Wilmot who basically first successfully cloned from the adult somatic cell of a sheep, and they called it Dolly. And however, Dolly died at the age of 6. So this particular Dolly, this is an animal, and the Rosalind Institute, which developed that cloning technology, applied to the US Patent Office for a patent on Dolly, and USPTO turned down that application, and it said that the subject matter of its patent exclude laws of nature, natural phenomena, and abstract ideas. So basically, even though she was not created through a natural process, the natural procreation process or a reproduction process, even though she was developed from an adult somatic cell of her mother, the problem was that Dolly was exactly similar to her mother. There was nothing new in Dolly. There was nothing inventive step in Dolly. She was basically a carbon copy of her mother. And it was held that because of that genetic identity similarity to her parent, Dolly cannot be patented. It can only be considered as a living thing. So we need to understand that when what we say, when you have a somatic cell cloning, the cloned adult will have the exact identical features of the cell donor. So in this case, they got a patent for the process of cloning, but they failed to get a patent for this cloned sheep. And then another case which is very noteworthy in this context is Association for Molecular Pathology versus Myriad Genetics. So in this case, it involved the patenting of a gene, DNA. So the question was with regard to, I'm sure you might have heard about this particular case. So the Association of Myriad Genetics, they were successful in identifying and isolating the gene which was causing the breast cancer. So it identified the BRCA1 as attached or as a part of the long arm of the chromosome 17. So this particular prognosis allows you to check your DNA and see whether in the chromosome 17 if you have a breast cancer gene. So some of you might have heard about Angelina Jolie taking up this genetic test and removing her breast, so that because she had a hereditary nature of having breast cancer in her family amongst their women, she removed the mammary gland so that she will not be getting a breast cancer. So the question was, they had two things. One, they had isolated the DNA which was attached to the long arm of the chromosome 17, and then they had the prognostic tool also. So the court opined that a naturally occurring DNA, which is part of a human being, is not patent eligible just because it has been isolated. But the cDNA, the component DNA, is something which was synthetic, which was developed by Myriad. That was patent eligible because it was not naturally occurring. So this cDNA, which was a DNA synthesized from a single stranded RNA, was not something which was occurring naturally, was not something which is existing in a human being. It needs to be engineered and created. So the cDNA was given the patentability criteria, but the DNA, the isolated DNA, the isolated BRCA1 gene was not given a patent. So the cDNA was not considered as a product of nature. However, the DNA was considered as a product of nature. Another case in which this biotechnology ethics etc. came into picture is the Mayo Collaborative versus Prometheus lab, where a drug, like when you administer a drug, if anyone has been taken a vaccination or taken an IV fluid, you know that how drugs are administered to your body. So a drug administering method is considered as a diagnostic method, as a determining the level of metabolite and what is the need to increase or decrease the drug amount. A software which would help you to do that was not considered as patent eligible, and it was considered as invalid. So they said that this is depending on the natural process of drug. So the like let us say whether you should take a paracetamol 500 mg or 1000 mg depends on the natural process of that drug. So you cannot claim a software which will allow you to say how much you need to take a patent. Similarly, the DNA primers and diagnostic method for identifying the DNA primers were also considered as an patent eligible matter. So it was not a patent eligible matter. Now, with this, I hope at least some of the patent exclusions and how it can be included into patentability is clear to the audience. We are moving on to the next part of my presentation, that is a patent grant. What is the process or procedure for getting a patent? So patent, first you need a concept which is you are developing, then you have a patent search, you have a patent drafting, then you file and the patent application is examined. Then you have a patent examination report or hearing, and you have the disposal, whether you may get a grant or refusal. Depends upon what we have discussed till now, whether it is a product or a process, whether it has newness into it, whether it has an inventive step, whether it has a commercial utility. All this set of standards will determine whether it is patentable. Once that is cleared, you will be looking into the section 3 and 4, which I discussed, that the patentable subject matter, plant, animal, etc., etc. So the whole thing is, the process comes into picture in this context. So when, like as a student, as a researcher, you know that when you're going for an invention, you need a conceptual theme coming up. You have a developed concept being developed by a group, or it might be individual. And then once you invent something, you have to go for what we say an activity called patent search. This patent search will allow you to check all the existing patents which are granted in that particular area and identify what is new in your patent. If there is nothing new in your patent, if there is you don't have that inventive step in your patent, your entire patent application process stops there. Now with the patent search, you see that, okay, there is still scope for my invention to get a patent. You go ahead with the drafting of your patent, and then you submit your application to the concerned patent office, and then the patent application is examined, and we go ahead with that particular process. So the first question is, who can file a patent? So in India, the application for a patent can be filed by any person claiming to be the true and first inventor. So that means the first inventor. The inventor himself is the first person who can claim or who can apply for a patent. Then any person who has been assigned by that person claiming to be the true and first inventor. So if you are associated with the lab, if you are associated with a particular university, particular office, your contract would say, on the employment contract, it would say who will have the right to patent. So even if you are a scientist working with NATCO, if you are working with Bayer or with CIPLA, you are only known as the true and first inventor, but the patent, the right to take a patent could be assigned to a person whom you are allowing to. And the third category is the legal representative. Like if you pass away after your invention is done, your legal heir can apply. But whenever it is any person other than the true and first inventor, it needs to be what we say, it needs to be supported by a document. Now, once this is particular done, it can be more than one invent rules. It can be alone or jointly. The form gives the details regarding that. So once you file a patent application, the patent application will be published to the general public after 18 months of your patent application. And this publication will make your patent, not your patent, your invention a public knowledge. So the only problem, the benefit you have is, even if after the publication, if you are given the patent, no one can produce or manufacture your patent for 20 years. Patent application does not keep your patent information or your invention a secret for 20 years. It will be in public after 18 months of your application. Your details of the invention will be available in the public. And once it is published, the general public, the general population will know what you are trying to patent. And if we have an opposition to that, we can go to the next stage of opposition known as the pre-grant opposition. And this pre-grant opposition is what we say is only the pre-grant opposition can be done by any individual. And if there is no pre-grant opposition, we'll go a little more detail into this process later in the coming slides. And if there is no pre-grant opposition, or the pre-grant opposition is successfully challenged, that means as an inventor, I was able to prove that the opposition is not right, I can go ahead with my application, that is request for the examination of my invention. And this would send my invention to a subject expert who will look into the patentability, whether it is new, whether it has inventive step, etc., etc. Then if I was not successful in protecting my patent in pre-grant opposition, the patent is considered as abandoned. It is rejected. Now, after the request for examination, if the patent examiner feels that mine does not have the required standard, there is a chance of it being rejected again. And after examination, let me just move on to that particular. Yes. So this is basically a quick look on how we grant patent in India. So once I have just started with it, but I'm repeating it once again. Once you have conceptualized an invention, you can go ahead with the filing of your application. So you have two ways of filing your application. One is with complete specification and the other one is with provisional specification. So specification is basically the explanation of your patent. So let us try to show you one. So I'm just showing you one search platform for patent. It is eSpaceNet. And let us just say, I'm just typing the most commonly used word, COVID. And I have more than 24,265 results for that particular COVID-related patents. So all these patents, so let me just click on one of them. I hope this is in English. Sometimes, yes. So this is basically how that patent is given, and it has an abstract. This is a patent application basically. There is an abstract, and we can look into different documents of this particular patent and where it is globally kept, etc. And all details, for example, on a particular invention will be identified for that. So this is a therapy for treatment of corona infections, more particularly COVID-19 infections. So this is the data in which the application is available at this number, and all the details will be available for you once you go to this patent search engine. So once this particular filing of application is done, you need to give an explanation of your invention. In India, we call it specification. There are two types of specification. First one is provisional specification, and the second one is complete specification. Usually, people go ahead with the provisional specification so that they can block that patent. Because as I said in the initial slide, it is first come, first serve when it comes to patent. Whoever is filing first has the highest chance of getting a patent. So to ensure that your seniority or your priority is not lost, you can file with a provisional specification. If you are filing with a provisional specification, you have to file the complete specification within 12 months. If you are not filing your complete specification within 12 months, your application will be considered as abandoned. That means your application ends at this stage only. On the other hand, you submitted with a complete specification, and then you go ahead with the publication of your invention. Or if you have submitted a provisional specification, you need to submit it within 12 months. Either way, you need to publish it within 18 months after your application. And once this publication is done, uh, there is the chance for pre-grant opposition, which if successfully completed, your application will go for the examination request. And if it is if it was unsuccessful, your application ends here. And once you submit a request for examination, the examiner looks into the patentability and other requirements, whether it is a prohibited subject matter, whether it is an excluded subject matter, etc. And once that examination is concluded, he will issue a first examination report, that is FER. And once the FER is issued, if there is no question, if all the standards and other things are cleared, you are going straight ahead for your grant. But if there are certain issues which the examiner has identified, there would be a re-examination of the amended documents which you have submitted. So once you get the first examination report, you are given a chance to clarify any issues which were identified by the examiner, and you can submit the amended documents. So this is re-examined, and there is an option for hearing by the controller. And the FER, after the FER is issued, you are only given 12 months to complete any issue which is identified in the first examination report. If those objections which are raised by the examiner is not met within 12 months, your application will be considered as abandoned. Or if you meet the objections within 12 months, you may be getting your patent under section 43, and the publication of the grant of patent will be done through the gazetted journal. Once that grant is done, don't think that our drama ends there. You still have a 12-month period for the post-grant opposition, where any interested person feels that this particular grant has been done against any law of the land, against any prior art, again it does have any other problem, then post-grant opposition can be taken. And again, the controller will hear the applicant and the opposer. And if you successfully clear that, your patent will continue. If you are unsuccessful, your patent grant will be denied. So this is basically the patent grant process. So there are different forms Okay. Where to file patent application and sorry, there are different forms which are given under the Patent Act and the related rules. So you have a Form 1, which is for the grant of patent. Your specification shall be in Form 2, and the statement and undertaking shall be Form 3. Power of attorney, in case it is through an attorney or through an assignee, you need to give a Form 26, and you have a declaration of inventorship and request for first examination, request statutory fees, etc. are given in the Indian Patent Office. You need to pay according to that. Now the question is where you need to file a patent application. You need to file it in the appropriate office within the territorial limit. It could be residence of the applicant, domicile of the applicant, place of business, etc. And if you are not an Indian, you need to have an Indian address for applying a patent in India. So basically, we have 4 patent offices. The headquarters is in Kolkata, and the branch offices are in Chennai, Mumbai, and New Delhi. And like in Kerala, the south zone goes to Chennai, the central zone and the what we say west zone goes to Mumbai. The so not the central zone, the western zone, and the western zone goes to Mumbai, and the plains, the central plains and the northern territory goes to New Delhi, and the rest of India goes to Kolkata. And I have been speaking about this complete specification, etc. So these are the essential requirements which you need to include in your specification. You need to give a prior art, like what is the existing art, what are the drawbacks, what are the solutions you have identified, what is the summary of your invention. You have to give a detailed description of your invention along with drawings, examples, or any prototypes which you want to submit to ensure that your patent is considered. But the most important concept is the claims. Claims is what you're going to claim your patent on. The invention is essentially given in the claims, and these are the steps which we have already discussed. This is the procedure for patent application. Once you are given a grant, and once the period for the post grant opposition is over, or the post grant opposition has been successfully fought, you have a patent granted to you, and you have all those rights which we had discussed previously available to you. So there are, once you get a right under a law, you have remedies which are available. So whenever someone does something with your patented invention without your permission, it is called as an infringement. So, primary infringer is someone who does this or cause that infringement or making the product. And a secondary infringement is where there is a commercial activity which is selling the duplicate or distributing for sale the duplicate, etc. And you have certain type of remedies which are available. You have civil action, that is, you can issue a stay order, preventing someone from doing some that. Criminal prosecution, you can there are criminal remedies for infringement, and you can claim the cost of your litigation. And the patent office will help you with the assistance from the enforcement division, including the police, will help you to ensure that your property is protected and your IP is vested with you. However, you always have to be vigilant when it comes to the patent infringement and other things. So when you start a civil action, you have a monetary compensation like damages, or when you have a criminal prosecution, there might not be any monetary compensation, but the infringer might be imprisoned, or he might be asked to pay a particular fine, and the trial cost is borne by the government in that case. But in civil action, whoever is initiating the civil action has the liability to take the cost. Now, what we need to understand is, this is a very quick and a very brief introduction to patent law and the procedure in India. So we need to understand that for most products, at the same time, simultaneously, you may have multiple patent laws, intellectual property rights available. So you may have different types of IP on a same object. So that doesn't cancel each other. What we need to understand is that whenever we are getting a patent that is related to invention, if we are getting a design, it is for the outer shape or contour or configuration. If you are getting a trademark, it is for a brand name or a logo for goods And if it's a copyright, of course, the camera has an instruction manual, booklet, etc., which is developed to it, or it might have a computer program. In the modern cameras, which are connected to the Bluetooth or something, it may have a computer software, which is also under the protected copyright. So with this, I come to an end of a quick class on patent law and its introduction. Uh, so should I go to the questions directly or?
Questions we will mount on your screen for
Yes.
easy comprehensibility, and others can also join in. But madam, it was a wonderful session with so
Thank
much
you,
of
sir.
in-depth analysis of each and every aspect. And your legal background has been brought out in full in this particular session.
I did not
So
make it legal, sir. I tried to dilute it
but
as much
the
as
cases and
possible.
case studies and all that, that helped us understand the legal side of the thing also. In fact, I felt as if I had gone back to my LLB classes once again, where all these law cases and others are to be discussed. And it was really wonderful. I'm sure our
Thank you,
learners
sir.
would have understood a lot on this. We'll quickly go through the questions. Sharma sir, shall we go through the questions first?
Yes, I think we should go to questions. It was very good presentation, elaborated with lots of examples you have given. That way,
Sir,
I think it will be very useful for the students right from the beginners to the that advanced level who are in the stage of patent filing also. Elaborated procedure you have explained, and then a lot of example, even the last example that you have taken almost all those parts, copyright, trademark, patent, and these all aspects with one example. That's a great thing. I think it is very simple and detailed explanation of copyright and patenting laws, procedures, and everything. Thank you very much.
Thank you, sir.
I think we can take questions.
Yeah, surely we will. And thank you for joining into this session, sir. In spite of your very busy schedule, you were able to make it to the session. That means
It's
a
my
lot for
pleasure.
us.
I have learned a lot. I have learned a lot because through this kind of sessions, I am also in the learning phase because when we are interacting with our students, sometimes this kind of experiences, learning, they help us in protecting ourselves. We are not experts, but we are learning like you. You have gone into your law classes. I have also become a learner of certain class. Like I am learning something very new. So it's a good, my pleasure.
Thank you, sir. We
Yes,
will
so
now
let
go
us
into
go
the
for it.
questions per se. The first question that we have is from Karthik Krishnan, and he asks, "What are the provisions in law to prevent misuse of patents?"
So, may I request Mr. Karthik to tell me whether it's a misuse by the patent owner or by the public?
I think what he means is the patent owner as such, because we do not have an interactive kind of
Okay, okay.
mechanism.
So
We'd like to ask
let
you
me
to
just
clarify.
answer from both perspective.
both,
Yeah,
So if it is the patent owner, we have the compulsory license which I discussed. I think it might have come later after the question was
yeah,
posted. So if the patent owner has taken a decision that I am not going to make it available for an affordable rate, the government can intervene and make sure the product is available for the public at an accessible rate. So that case, the Bayer case which I discussed, I am sure would have, like, how many families can afford in India 2,80,000 per course. So the government had intervened, government through the patent office or through the judiciary has intervened and brought down the price of that particular drug to 8,900 rupees. So that is something which most of the families can afford. I would not say still that everyone can afford, but at least 50 to 60 percentage may be able to afford with some external help, etc. So that is one way of ensuring that the patent owner doesn't misuse. Second is using the patented invention for the research or any other purpose. That is also permitted under the patent law. Government use, health emergency. So, for example, during COVID, one of the main issue was availability of the oxygen. So if the private companies were hoarding the oxygen, the government could have taken it. Similarly, in a patented product, in case of an emergency, the government needs it in bulk quantity, it may procure that for a particular period of time. There will be some sort of compensation known as a royalty, but it not be the exact patented price. Then third way is like, not making your patent at all. Like I took a patent, but I am not manufacturing the process. Then the government can revoke the patent, can take away the patent. That is from the perspective of a patent misuse by the owner. Or you have the what we say, the patent commission, sorry, the competition coming in, the drug control prices act coming in. You have different regulatory mechanisms that can step into, not in its entirety because patent is excluded most of the time, but there are scope for judicial intervention and policy interventions. Then if it is by the third party, those are the remedies which I discussed, the civil remedies and criminal remedies. If I'm infringing upon someone's patent, they can take an action against me. If it's a civil action, I have to pay my compensation as damages. If it's a criminal action, I may have to go to the prison or pay the fine. So I think that question would be clear.
Yeah, I'm sure that would have been addressed. Now, the second question is from CG Ratish, and she asked this question: what are the important aspects which a student innovator has to keep in mind while patenting implementation?
Okay. First thing is like in the stages of a patent process, I told you about conceptualization of an idea. You have to understand most of the time that particular documentation allows you to get your patent because you are in a group and we belong to different systems, different labs. Anyone can take away your idea and start working on it. So, to prove that you started working on it first, all patent offices ask you to keep a journal of what is happening. So, as a student, I would say you keep it in soft copy, hard copy, doesn't matter. The moment you start conceptualizing, you start documenting it. That's the first thing. Second, if you are part of a research project, if you are part of a lab, you need to be conscious of the contract to which you are agreeing to. Sometimes you may invent something, but you might not be known as the true and first inventor. We should not consider that law, the whole world is very just and equit. There is no equality, fairness, and justice as such. You need to ensure that in the contract, what is your provision? What is going to be your role once that particular project is over? Then the next step which you need to be very clear is whether your that idea which you conceptualized and developed in an invention is a patentable subject matter or not. If it is falling under a non-patentable subject matter, it will be rejected on the first instance. If there is existing technology, there is existing. So recently, one or two students came to us and said that they want to find a new way of search engine. So for that search engine to be patentable, it should be something new than Google or Firefox or Edge. If it is similar to that, there is no inventive step in it. So you need to ensure that it is new, it has an inventive step, and it has a commercial utility. Now, for this, you need to do that particular term which I said, that is patent search. There are different patent search offices. In India, we have it in impasse. So you can go to the patent office, you can search the patent. There is WIPO patent search. There is European patent search. Each of the major patent and trademark offices had their own databases. You need to check whether anyone else had patented it or not. And once you are sure that there is enough inventive step, there is enough novelty, you can go ahead with your patent application. But ensure that you are not caught in pre-grant opposition and post-grant opposition. You are adequately acknowledging your teammates. So there is an adequate, like suppose 5 of us found an invention, like found something, and I am claiming as the true and first inventor. Naturally, all 4 of you will oppose me because all 5 of us have together started that. So you need to have an ethics also when you're claiming to be the true and first inventor. Rest of the thing will be according to the law and the procedure for grant of patent.
The next question is from Neetu Vineet. And
Yes.
she asks, is patent to be applied in all countries where invention is to be operated?
Yes. A patent, as I said, is a statutory right given by a law. That means Indian law can give patent in India only. If you need a patent in US, you need to go and file a patent there. You have three ways of filing patents in different countries. One way is the normal one where you find in your domicile country. Then you go to the next country, apply there, or you simultaneously apply in different countries. Or you have the second route. We have a Paris Convention for the Protection of Industrial Property, which allows you that if you are a member of that particular treaty, your country is a member of that particular treaty, and you file a patent application in one country, you can get 12 months priority to file in any other member of Paris Union. So that is Paris route. You file in India and within 12 months you file in any other country you need to file. There is no need to file in all countries. Your product might not be launched in all countries, but if there is a chance that your product might be infringed, it's better to go for a patent. Or you have the third route, that is a patent cooperation treaty, that is a PCT. So PCT is you apply to one patent cooperation treaty designated office, and then you identify different countries in which you want to apply. So after the preliminary international phase, PCT will forward your application to the designated countries. But you have to pay the fees in each country. But technically, coming to the point, you need to apply in different countries for the patent in those countries. A single application will not solve in all countries. You can have a single window, but a single application will not work.
Oh, that is, I think, quite an important information as such. And the next question is from Reshma. I think you have partially covered this aspect. If we are a team of researchers, who can apply for patent out of all of us?
All of you can apply
Yeah.
on one way, true and as a true and first inventor. All of you can jointly own a patent. On the other hand, if you feel that only one of you is the core person, so I don't know whether I should say that sometimes in a lab, the project leader or the professor in charge might be the true and first inventor, and you might not be recognized. It all depends on the way in which you are employed at that particular company or the office or the lab. But if it is someone else, suppose I am employed in QSAT and I find a patent, and I find an invention, but suppose my contract says that any IP which I created during my tenure would belong to QSAT. Universities do that because you are using their lab and you are getting a stipend or a fellowship also. So most of the time, the research scholars are considered not as students, they are considered as employees in these universities. So the contract of service will apply there.
The next question, what is the guarantee that the patent office will keep my invention secret?
There is the purpose of patent is to ensure that your invention is in public. So within 18 months of your patent application, the application is published because people need to know what you're trying to appropriate from the public domain. And if I feel that you are taking, for example, turmeric patent, so they found some antiseptic uses for turmeric and try to apply for a patent. And we always allege Western states and developed countries for biopiracy. What we should actually do is we should go to the patent application and see who is the applicant. In turmeric case, it was two people from Hyderabad. So they were like, our people only who had the knowledge of the uses of turmeric and went there and tried to patent. And it was because it was published that we knew that someone is trying to patent our turmeric in US. So the purpose of patent is to ensure that the invention which you have found, the specification will allow another person after your patent term is over to recreate the same thing. So a person skilled in the art should be able to recreate your invention after 20 years. So you don't have any scope of keeping your details secret. The only benefit is that you will get 20 years for your patent. No one else can make or use or sell without your permission the patented invention. So in the first 18th month itself, your application is going to be in public domain.
But one thing that many people come up with a query is that the patent is granted from the date of application. Now,
Yes.
once the patent office may take its own time, these 18 month deadlines and all that, to grant the patent on the actual basis. Now, in the meantime, can't we actually operate the patent on a provisional basis?
You can. Your patent might be, what we say, your product or process might be available in the market, and you will have patent pending attached to your product. If you look at the packages, you might have seen patent pending. That is the process. So now, with what we say, the ease of doing business ranking and the World Bank ranking, etc., in our head, we had ensured that the patent office is very quick in processing the applications. So I think at times it has even issued the patent within 2 years also, within 18 months, 14 months, it has issued the patent because it has sped up the process. The complete specification was filed, immediate first examination request was done, and the oppositions were successfully dealt with. So in such cases, you can easily get the patent within 2 years. But as of now, on an average, it might take 3.5 to 4 years. But as you said, there was one instance recently where it took 19 years for the patent application to be processed because it was not a patentable subject matter at that time. However, after TRIPS, it was considered to be patentable and it went on with regard to the patentability, inventive step, etc. So the patent grant is from the date of the application, not from the date of the grant.
But suppose if during the period which is taken for decision making, a substantial profit has been appropriated by the company concerned, and later it is found that it is not a patentable subject matter or the patent cannot be granted on any other ground. Are there any remedial measures?
Remedy for whom, sir? For the applicant?
No, in fact, he must have done some social disservice by operating
No,
that
no, no.
particular patent.
You can't take back what you have paid. That becomes his profit. So patent being rejected has nothing to do with the product's commercial success.
Success, okay.
Sometimes the patent might be granted, but the product might be a, failure
Failure.
in the market. Sometimes there might not be no product, and still it could be a huge success. So, for
Exactly.
example, that Jaipur legs, that prosthetics, the inventor did not apply for a patent, but look at the wide application of that.
Exactly.
So, yes,
Thanks. Now I'd like to request
I
my colleague,
think this revenue generation and success and the patent, they are not correlated. They are not linked with each other. Something may
no.
not be patentable at all, but can be a very good source of business or revenue generation. That's
See, for
quite
example, sir,
possible.
COVID vaccines.
Yes.
None of the vaccines are patented, but look at the commercial success of that. I mean, the money those people made out of it, in spite of government funding for it, they charged. So those are the realities, the sad realities. But still, we stick on to the what we say, the traffic light, preventing the traffic accidents.
Yes. Right. That's right.
Pramila madam, would you like to make any comment or your observations, please, on this issue?
Madam, your class is very informative to me. Persons like me who are not
Thank
a basic information about law and other things. But in the case of turmeric, I have a doubt, and you already cleared it, madam.
you.
I
Yes.
think that is the India government of India successfully challenged that, and they have
Yes.
it is withdrawn. I think.
Yes, see, there were certain
Uh,
NGOs that happened with the
okay.
Neem case. Then even the Bikram yoga, if you have heard
Uh,
about it, the normal yoga which we do is like sped up with a high intensity yoga, and he wanted to copyright the postures of the yoga.
yeah.
That
Okay.
Surya Namaskar postures, all he wanted to copyright, but that was not accepted.
Accepted.
Same is the case with basmati rice. Even though it's not a patent, it's a GI. A company, an agriculture company in Texas, cultivated basmati in Texas. And think of Texas climate and the Himalayan foothill climate. So the basmati growers were concerned that the rice which is grown in Texas will not have the same softness or the fragrance of basmati or the taste of basmati. So they successfully challenged it in US, and the US court said that okay, you cannot sell it as basmati, but you can sell it as taxmati. So it's a Texas grown basmati taxmati, not the Indian grown basmati.
Thank you, madam.
Thank you.
Madam, Pramila, madam, you are about to ask the same thing or something else you wanted to add, ma'am?
No, the same
Only,
thing,
okay.
madam. Sir.
Okay, fine, fine, fine.
She has quoted
I
other
just,
examples
I
also.
just expanded it with two, three other examples.
Okay. Dr. Praveen, would you like to make any comment or any visualization on this matter?
Sir, actually, it was a very, very comprehensive topic by Dr. Kavita madam. And madam has covered right from the basic concepts for a layman like me. So starting from the movable and immovable asset concept up to the latest basmati trips, Jaipur lakes, and various other issues and case laws madam has covered. It was definitely very interesting to hear, sir. So I'm really thankful that I have attended this session.
It's my pleasure, sir. Thank you so much for the positive
Okay.
comments.
Sharma sir, any final thoughts, sir?
Recently, we have created a patent facilitation unit at the university because we came to know that many of our students not aware of basically these basic concepts and the procedures and the differences also for what I can file for copyright or patent or not. Like many examples you have given. So this patent facilitation unit, we plan to have this kind of more focused program, and I think this is a good beginning today that Dr. Arias has done. And because we have to reach out to all the students in the country, and this will be certainly through the regional center. And so that way, I think we will be traveling you again for this purpose, and hopefully we'll get your support, cooperation in this context.
Of course, sir.
Second thing, recently we have announced an idea competition. You know, all universities are doing this kind of thing. So we have also announced the idea competition, and many of our students are submitting their ideas. Some of the ideas are very original. Some of them are, you can see, they have been searched from different sources. But many of our students are they are basically afraid of if I share the idea or the methodology or mechanism behind that, will it be protected? Will it be somebody will not be misusing it? So what kind of message or what kind of something that you would like to convey to the students? Like if you are submitting your idea, what you should share and what you should not reveal, up to what extent you can do, and then in fact if we are not coming up with ideas for this kind of competition, then I think that purpose will be defeated, because our purpose is to generate new ideas. And if they
Yes.
are not generating, they might be generating new ideas but not sharing or not revealing those ideas, then also that is useless. So for those students, would you like to say something?
Yes. So what I would suggest is that when it comes to patent, confidentiality is the highest issue, sir. I won't say that you share whatever you know with others unless you are in a contractual and confidential relation between those participants. The type of ideas you share with others should be done very cautiously, and the documentation of each and every activity should be done. On the other hand, if it is with regard to any publication, of course, you write and then you discuss. So there are instances, I'm just talking about the good fact. You have the sad reality where the ideas are stolen, where poor children are taken away from their inventions, where you're forced, especially in IT sector. Like if a small startup is coming and they have a contract with a bigger company, all the future developments by that startup would belong to that company. So the unequal relationship between the parties are a fact when it comes to the knowledge economy. And knowledge economy is where, like at that time, the only option, sometimes you think that, I won't blame the students also when they say I don't want to share. Maybe that's the right way to do certain things at times. But again, it would all depend upon the contract which you have entered. Suppose you are in the same lab, you can easily discuss the inventions, the ideas. But if you are not in lab, so one of my, like if you have an interaction, if there is a like this is the age of MOUs and international cooperation. So suppose you have an MOU with a US university, and both the university students are conducting an scientific research, and it actually happened that the students in a developing country or a biodiversity rich country, you identify a particular phenomena and you sequence it. Digital sequencing of that particular genetic information or the DNA was done, and you share it with your American counterparts as a part of your research sharing. What essentially happened was that they took the sequence, and that group of students filed for a patent in US. Now the question is, they only use the DSI for identifying a product. So even with confidential MOUs or contracts, there is misappropriation happening. So you have to be very cautious on how you are going to go ahead with that. That is why many companies, when it comes to their core function, like the Google search or these recipes, etc., they don't go for patent. As one student asked, patent will not keep it confidential. Patent will make it public. So till you reach the patent, till you get the first inventorship or first applicant status, you need to be very cautious with whom you are sharing the data or not. The data
That's
can
right,
be
because
shared, but the findings needs to be very cautiously shared.
normally it happens even among the friends and teachers also do this kind of
Yes.
things. Thank you.
Thank you, sir. Thank you for
I
that
think we can.
intervention.
It's
And
a very wonderful presentation. We can conclude it if
exactly.
you think so.
Yeah, sure. I know that most of the queries have been addressed, and our colleagues are also have quenched their thirst for knowledge. Now it is most appropriate that our Assistant Registrar, Dr. Praveen, proposes a formal vote of thanks. Before that, I would like to state that, as Sharma sir had just now mentioned, we'll be troubling you again and again for various academic favors from your end,
No
and
issues, sir.
that
No
this
issues.
between our institutions continue in full steam. That's our hope. And now may I formally invite our Assistant Registrar, Dr. Praveen Kumara, to propose a formal vote of thanks.
Thank you, sir. A very good evening to one and all present here. I deem it a great honor and privilege to propose the vote of thanks on the occasion of discussion of the topic, an introduction to patent law and procedures in India by Dr. Kavita Chalakal, Assistant Professor, Cochin University of Science and Technology. First and foremost, I thank Dr. O.P. Sharma, Director, NCIDE, IGNOR New Delhi, for the presidential address and for giving a brief on the thrust area of NCIDE, namely development of innovative learning solution, development of innovative support solutions, capacity development, incubation and nurturing innovation. Sir, thanks a lot, sir, for your presence and for your valuable address. I thank our keynote speaker, Dr. Kavita Madam, for enlightening us on the topic pertaining to patent law and procedures in India. The speaker was comprehensive in covering the patent law and related aspects. The speaker started with the basic concepts such as movable and immovable property and its rights, and moved to higher concepts which included IPR, patents, WIPO, geographical indicators, and various other sub concepts in the patents. The speaker also covered concepts such as reverse engineering, compulsory license, etc., which were actually very thought-provoking. And a lot of examples, illustrations were given, like the Bayer and Union of India and NATCO. Such examples were really very interesting to learn. We also thank you, madam, for patiently responding to all the comments of our viewers and learners. I sincerely thank Dr. M. Rajesh, Senior Regional Director, IGNOU Regional Center, Vadagara, for organizing this webinar in spite of his busy schedule and for giving me this opportunity. Thank you, sir. I thank Dr. Pramila, Assistant Regional Director, for the wonderful introduction of Dr. Kavita Madam. I also thank all the staffs of our Regional Center Vadagara, colleagues of other regional center across the country, and study center coordinators, academic counselors, dear learners, and the public for actively participating in this webinar. I'm sure this webinar would have been very interesting and would have quenched our thirst for knowledge. I thank our Kavita madam on behalf of all of us. Thank you, ma'am. Thank you, one and all.
Thank you, sir.
Thank you,
Thank
ma'am.
you. Thank you very much,
everyone.
to all of you.
Thank you,
From
sir.
our side, it has been wonderful having you with us, and hopefully in the near future we will have another session with you with the kind cooperation and permission of Sharma sir.
Yes, we'll have. We'll have.
Thank you,
So
sir.
with your kind permission, shall we bring the session to a close, sir?
Yes, please. Good night to all of you.
Thank
Good night, sir. May I leave the meeting?
Yes, please.
Yeah, please.
Thank you,
Thank
everyone.
you.